Okay, local civil rules, U.S. District Court for the Eastern District of North Carolina, page 13, Rule 1.1, Scope and Citation of Local Civil Rules. These local rules shall govern civil actions and proceedings before the United States District Court for the Eastern District of North Carolina, except when federal statutes and rules govern. In admiralty cases, where a local civil rule is inconsistent with a local admiralty rule, the local admiralty rule shall apply. In patent cases, where a local civil rule is inconsistent with a local patent rule, the local patent rule shall apply. These local rules should be construed, administered, and employed by the court and the parties to secure the just, speedy, and inexpensive determination of every action and proceeding. A judge or magistrate judge, for good cause, and in his or her discretion, may alter these rules in any particular case. These rules shall be cited as local civil rule. The local civil rules posted on the district website, http whatever, look it up yourself, shall be the court's official record of such rules. Rule 2.1, reserved for future purposes. Rule 3.1, subsequent litigation by parties, proceedings in forma pauperis. A plaintiff who has proceeded unsuccessfully in forma pauperis and had the cost of that litigation taxed against him or her must demonstrate that he or she has paid or made a reasonable effort to pay those costs prior to being authorized to proceed again in forma pauperis. Rule 3.2, denial in forma pauperis applications. In all civil actions in which the court denies the plaintiff's motion to proceed in forma pauperis, the plaintiff shall be allowed 30 days to pay the, requisite filing fee. If the plaintiff fails to pay the filing fee, the clerk shall redesignate the action as a miscellaneous case and close the matter without further order from the court. Rule 4.1, reserved for future purposes. Rule 5.1, filing and service of papers. A. Electronic filing. A1. Parties' pleadings and other documents, unless otherwise permitted by the Electronic Case Filing Administrative Policy and Procedure Manual, Policy Manual, or otherwise authorized by the assigned judge. All documents submitted for filing shall be filed electronically in text searchable format using the Case Management Electronic Case Filing System, CM/ECF, and in management and in accordance with the policy manual. A document shall not be considered filed for the purposes of the Federal Rules of Civil, Criminal, or Appellate Procedures until the filing party receives a system generated notice of electronic filing, NEF. Any document electronically filed or converted by the clerk's office to electronic format shall be the official record of the court. As such, the clerk's office will not maintain a paper record of these documents. The clerk's office will not accept any email or facsimile transmission for filing unless ordered by the court. Rule 5.1A2. Court-generated documents. All orders, decrees, judgments, and proceedings of the court will be filed in accordance with the policy manual, which shall constitute entry of that document on the docket kept by the clerk under Rule 58 and 79 of the Federal Rules of Civil Procedures. All signed orders will be filed electronically by the court or court personnel. Any order or other court-issued document filed electronically without The original signature of a judge or clerk has the same force and effect as if the judge or clerk had signed a paper copy of the order or other court issued document, and as if it had been entered on the docket in a conventional manner. Orders may be text only. Entry on the docket without an attached document. Such orders or official and binding. Registered users, filing users. Only an attorney who is registered in CM forward slash ECF may file documents electronically. Resignation constitutes written consent to service of all documents by electronic means as provided by federal rules of civil procedures and the policy manual. 2. Receiving users. A pro se party who is not incarcerated may register to be a receiving user of CMECF. A receiving user receives notice of filing by email instead of by regular mail, but may not file electronically. Registration as a receiving user constitutes written consent to service of all documents by electronic means as provided by the Federal Rules of Civil Procedures and the Policy Manual. C. Signature. The electronic filing of a document by an attorney who is a filing user shall constitute the signature of the attorney rule under Rule 11 of the Federal Rules of Civil Procedures. No attorney shall knowingly permit or cause to permit the attorney's CM forward slash ECF password to be used by anyone other than an authorized employee of the attorney's law firm. No person shall knowingly use or cause another person to use the password of a registered attorney unless such person is an authorized employee of the attorney's law firm. D. Entry of docket. The electronic filing of a document in accordance with the policy manual shall constitute entry of that document on the docket kept by the clerk under Rule 79 of the Federal Rules of Civil Procedure, except in the case of documents first filed in paper. A document filed electronically is deemed filed at the date and time stated on the NEF that is automatically generated by CM forward slash ECF. E. Service of document. Transmission of the NEF that is automatically generated by CM forward slash ECF, except as provided in subsection F below, constitutes service of the file document on registered party users. Parties who are not registered users must be served with a copy of any document filed electronically in accordance with the Federal Rules of Civil Procedures. When more than one attorney in a law firm appears in a case and not all the attorneys are registered filing users, service of any court generated document, i.e., orders, notice, etc., will only be made on the attorneys registered in CM forward slash ECF. It is the responsibility of the law firm's electronic users to notify all other firm members appearing in the case who are not receiving electronic notification. Non-registered attorneys will not receive paper copies from the court. F. Exceptions to electronic filing. Documents filed by a party who is not represented by an attorney permitted to practice in the Eastern District of North Carolina and registered in CM forward slash ECF, and those documents listed in Section V.A of the Policy Manual shall be filed in paper and are excluded from electronic filing. Any document filed in paper that is not exempt pursuant of this section must be accompanied by a motion for leave to file the document and proposed order. When filed in paper form, the document must contain the original signature of the attorney of each unrepresented party and must be served upon opposing party as provided in Federal Rules Civil Procedures 5B. G. Personal identifiers. The responsibility for redacting personal identifiers rests solely with counsel and the parties. The clerk will not review each filed document and any attachment for compliance with Federal Rule Civil Procedures 5.2. Rule 5.2. Appearance in civil cases. A. Notice of appearance. Counsel shall file a notice of appearance with the clerk and serve all parties. The signature block in the notice of appearance shall be in compliance with the requirement of the signature block illustrated in Local Civil Rule 10.1. The attorney shall also contemporaneously file a disclosure statement in accordance with Federal Rule Civil Procedure 7.1 and Local Civil Rule 7.3. Notice of self-representation, subsection 1. A non-incarcerated party who is proceeding without an attorney shall file a notice of self-representation on a form available from the clerk. This notice shall be filed when the party initially appears in action as required by subsection E of this rule. The self-represented party shall also contemporaneously file a disclosure statement in accordance with Federal Rule Civil Procedure 7.1 and Local Rule 7.3. A corporation, a limited liability company, a partnership, a trust, an association, or any other entity that is not a natural person cannot appear pro se. It must be represented by an attorney in accordance with Local Civil Rule 83.1. Except as otherwise permitted by law, no self-represented party may appear on the behalf or another self-represented party. Subsection C. Substitution of counsel. Whenever an attorney of record in a case will be replaced by another attorney who is an active member of the bar of this court, a notice of substitution of counsel must be filed. The notice must be signed by and contain a signature block for both attorneys in compliance with Local Civil Rule 10.1. Identify the parties represented. Verify that the attorney entering the case is aware of and will comply with all pending deadlines in the case, including proceeding with any scheduled trial of hearing, and which is 4, be served on all parties. Upon filing of the notice, the clerk's office shall terminate the withdrawing attorney from the case, and the new attorney will be added as counsel of record without order of the court if the notice does not comply with this rule. The clerk will issue a notice of deficiency, and withdrawal attorney shall remain attorney of record. D. Notice of withdrawal of government counsel. When a local, state, or federal government attorney has filed a notice of appearance in a case but is no longer associated with it, and there is at least one other active governmental attorney who has filed a notice of appearance in the case, the active governmental attorney shall file a notice to withdraw of government counsel to withdraw the appearance of the governmental attorney who is no longer associated with the case. The notice of withdrawal must be signed and filed by the active governmental attorney. Certify that the withdrawing attorney is no longer associated with the case and be served on all parties. Upon the filing of the notice of withdrawal, the clerk's office shall terminate the withdrawing governmental attorney from the case without order of the court. The attorneys to whom this subsection applies includes attorneys employed by the Office of the Federal Public Defender. Motion to withdraw. In all other instances, any attorney shall by motion seek leave of the court to withdraw his or her notice of appearance. Any motion to withdraw shall 1. Contain the last known mailing, and if different physical address of the moving attorney client. 2. Contain a description of the procedural posture of the case. 3. State whether the client consents to the motion and, if applicable, 4. Include a certification by the moving attorney that the client cannot be located or for any other reason cannot be notified regarding the motion to withdraw. If withdrawal would leave a party without representation, the motion to withdraw shall be accompanied by a proposed order granting the motion on a form available from the clerk stating that 1. Within 21 days after entry of the order or within the time otherwise required by the court, the unrepresented party shall file a notice of self-representation or cause new counsel to file notice of appearance. 2. No corporation, limited liability company, partnership, trust, association, or other entity that is not a natural person may appear pro se, but must be represented by an attorney in accordance with local civil rule 83.1 and 3. A party that fails to file a notice of self-representation or cause new counsel to file notice of appearance may be subject to sanctions, including but not limited to dismissal or default judgment. Rule 5.3 Removal and post removal procedures. A. Filing state court and other documents. Any party that files a notice of removal shall file with the notice of civil cover sheet a supplemental removal court cover sheet if available from the clerk and true and legible copies of all proposed pleadings, orders, and other documents that have been served on the party in state court, excluding discovery. The removing party shall file each served state court paper as a separate and distinctly titled exhibit to the notice of removal. 2. No later than 7 days after filing of the notice of removal, the removing party shall file a notice that the party filed in state court to comply with 28 U.S. Code subsections 1446D, except for the filing of a supplemental removal cover sheet. Subsection A of this rule shall not apply to removal pursuant to 28 U.S. Code subsection 1442 D1. Notice of appearance in removed cases. The removal of a case to this court does not relieve attorney who appeared in the other court of their obligations to their client. Within 14 days after removal, counsel for all parties in the state court action shall file either a notice of appearance, a notice of substitution to counsel, or a motion to withdraw in accordance with local civil rule 5.2. Any individuals who were representing themselves at the time of a removal shall file a notice of self-representation in accordance with local rule 5.2b1 within 14 days after removal. An attorney in a removed action who is eligible for admission to the bar of this court but is not yet admitted may file an application for admission to the bar of this court at or before the time of the attorney's notice of appearance. In that instance, the notice of appearance shall state expressly that it is contingent on the attorney's application for admission being granted. If counsel is not an electronic filer in the district, counsel may file the motion to withdraw or notice of appearance in paper form as long as the motion for leave to file in paper form accompanies the motion to withdraw or notice of appearance. C. Pending motions at the time of removal. 1. A party filing a notice of removal shall list on the supplemental removal cover sheet any motion filed in the state court that is pending at the time of removal. 2. If at the time of removal a motion is pending for which no supporting memorandum of law has been submitted to the state court, the movant on the motion shall file a supporting memorandum within 14 days of the date of removal, unless the motion is of a type covered by local civil rule 77.2 or unless otherwise ordered by the court. The local civil rule 7.1f deadline for a response to the motion runs for the date of the movant filing of a supporting memorandum in this court. 3. If at the time of removal a pending motion was supported by a memorandum of law, any response to that motion shall be filed 21 days after the removal unless otherwise ordered by the court. 4. Subsection C of this rule shall not apply to proceedings removed pursuant to 28 U.S. Code subsection 144D1 unless the pending motion relates to the proceeding being removed. D. Disclosure of affiliation and financial interest. Within 14 days after the filing of a notice of removal, all parties shall make the disclosures required by Local Civil Rule 7.3, irrespective of the provisions of subsection B of this rule and Local Civil Rule 5.2a. E. Cases relating to bankruptcy cases. Removal under 28 U.S. Code subsection 1452 or 28 U.S. Code subsection 1441 and cases related to bankruptcy cases shall be filed with the bankruptcy court. Rule 6.1. Motions for an extension of time to perform act. All motions for an extension of time to perform an act required or allowed to be done within specific time must show good cause, prior consultation with opposing counsel and the views of opposing counsel. The motion must be accompanied by a separate proposed order granting the motion. Except as ordered by the court designated secured leave under Rule 26 of the General Rules of Practice for the Superior and District Court of the State of North Carolina shall not be the sole basis for an extension of time of continuance. Rule 7.1 Motion Practice. A. Time for filing all motions in civil cases except those relating to the admissibility of evidence at trial must be filed on or before 30 days before the conclusion of the period of discovery. In an extension of the original period of discovery is approved by the court, the time for the filing motion is automatically extended to 30 days after the new date unless otherwise ordered by the court. General requirements. All motions shall be concise and shall state precisely the relief requested. Motions shall conform to the general motion requirement standards of the practice set forth in the applicable Federal Rule of Civil Procedures and in Local Civil Rule 10.1. If a moving party is aware that an opposing party consents or does not object to a motion, the motion shall so state. This subsection does not require a party movant to confer with any opposing party before filing a motion, although other provisions of these rules may require a movant to do so. If a party moving for non-dispositive relief is aware at the time of filing the motion that is consented to or not opposed, the party shall file with the motion a proposed order allowing the relief sought. If the party becomes aware after filing the motion that it is consented to or not opposed, the party shall file a proposed order allowing the relief sought as soon as practicable after becoming aware. Discovery motions. For purposes of the local civil rules, a discovery motion is any motion or other request to the court that seeks to enforce, use, regulate, extend, modify, nullify, or limit any of the procedures in any of the rules 26 through 37 of the Federal Rules of Civil Procedures or in any of local civil rules 26.1, 30.1, 33.1, 34.1, or 36.1. A motion of other requests to the court that seek to enforce, use, regulate, extend, modify, quash, or limit any pretrial civil subpoena is likewise a discovery motion. No discovery motion will be considered by the court unless the motion set forth or has attached thereto by item the specific question, interrogatory, etc., with respect to which the motion is filed, and any objection made along with the grounds supporting or in opposition to the objection, counsel must also certify that there has been a good faith effort to restore discovery disputes prior to the filing of any discovery motion. Motions for attorney fees in certain Social Security cases. Any motion for attorney fees under 42 U.S. Code subsection 406B or 1383 D2 shall be filed within 65 days after the date of the last notice of award necessary to accurately calculate the total amount of retroactive benefits, unless extended by consent or order. Supporting memoranda, except for motions which the clerk may grant as specific in Local Civil Rule 77.2, all motions made other than the hearing or trial shall be filed with an accompanying supporting memorandum in the manner prescribed by Local Civil Rule 7.2a, where appropriate, motions shall be accompanied by affidavits or other supporting documents. Response to motion. Any party may file a written response to any motion. A response shall be in the form of a memorandum in the manner prescribed by Local Civil Rule 7.2a, and may be accompanied by, without limitation, affidavits and other supporting documents. F1. Non-discovery motions. Response and accompanying documents shall be filed within 21 days after service of the motion in question, unless otherwise ordered by the court or prescribed by the applicable federal rule of civil procedures. F2. Discovery motions. Responses and accompanying documents relating to discovery motions shall be filed within 14 days after service of the motion in question, unless otherwise ordered by the court. Replies. Non-discovery motions, replies to responses are discouraged, however, except as provided in Local Civil Rule 7.1G2, a party desiring to reply to matters initially raised in the response to a motion shall file the reply within 14 days after service of the response unless otherwise ordered by the court. F3. G2. Discovery motions. Replies are not permitted in discovery disputes. See Local Rule 26.1d. H. Subsequently decided controlling authority. A suggestion of subsequently decided controlling authority without argument may be filed and served at any time prior to the court's ruling, and shall contain only the citation to the case relied upon if published, or a copy of the opinion if the case is unpublished. Affidavits. Ordinarily, affidavits will be made by the parties and other witnesses and not by counsel. For the parties, however, affidavits may be made by counsel for a party if the sworn facts are known to counsel or counsel can swear to them upon information and belief, and the facts relate solely to an uncontested matter, or the facts relate solely to a matter of formality, and there is no reason to believe the substantial evidence will be offered in opposition to the facts, or the facts relate solely to the nature and value of the legal service rendered for the party by such counsel or counsels, law firm, or the refusal to accept the affidavit would work a subsequential hardship on the party, and the court finds that its acceptance of the affidavit would not be such as to require that counsel or counsel's law firm be qualified from continuing to appear for the party. Hearing on motions. Hearing on motions may be ordered by the court in its discretion unless so ordered motions shall be determined without a hearing. Memorandum. Rule 7.2. We're going to take a break here.